Hi, I'm Jette Ferguson with Sotheby's International Realty here in Carmel, California. People call me Jet. And I'm here today with Kyle Krasa, attorney of Krasa Law in Pacific Grove. Thanks so much for coming onto the show.
Well, thank you so much for having me. I really appreciate being here.
You're welcome. So I would love to talk today about, I'm going to throw you off, okay?
Well, we'll see.
Without
Let's see
warning,
if you can. Let's see if you can throw me.
Because I've had this come up so many times where I have clients wanting to save money and they want to do a trust. It's like picking a discount realtor, right? Mm-hmm. You get what you pay for?
Right.
So that's what I'm guessing the answer will be. But I have them going, oh, I can just pay $500 online and do a trust. Mm-hmm. I've seen some big problems with that. What have you seen?
Well, certainly there are a lot of problems with that. I mean, a lot of times clients will say, well, my situation is simple, so why can't I just, all I just want to do is give my assets to my kids or whatever
Sure.
the example might be.
Mm-hmm.
And I would have a couple comments. One is that your situation is probably not as simple as you think it is.
It never is.
Anytime a client says to me their situation is simple, that's like a red flag. Oh, now it's going to be really complicated. But even if your situation truly is simple, what I tell my clients is that the law is not simple. You have, when you were talking about inheritance and passing assets on to a beneficiary of your choice, you have to navigate the California probate code, the Internal Revenue Code, treasury regulations, the civil code. There are all kinds of different areas of the law that have to be navigated properly. And that's why you see legal documents and trust documents that are long in detail. And I think that...
Yeah, mine's this big.
Well, that's because I drafted
and
it,
I was simple, right?
You were simple. But the issue really, a lot of times people think, they say, I just want a simple document, right? And you kind of conflate the length of the document with complexity, right? So you think the longer the document, the more complex it is. And I think with trust and estate planning, it's really the opposite, because all that you have to speak for yourself after you've lost capacity or passed away is what your estate planning documents say. So we really need to make sure that everything we can think of, every law that might be addressed, might be touched, right? Laws could change, so we want to have flexibility built in. We want to think about every contingency. A lot of times when we think about estate planning and who's going to survive us, we make these presumptions about who's going to be around, and who's going to be available to do things, and that's not always the case.
And then you have to say, if this person isn't alive, or if this couple is divorced, then...
all those kinds of contingencies should be built in. And so it's really important to have a comprehensive plan that covers that, and just some, form online is just not going to be able to navigate that. There's just really no way for a kind of a set-up interview to answer these questions. You don't even know what those questions are when you're filling it out. And there are examples. There are court cases where people have tried to fill out an online form, and they made basic mistakes that any attorney would be able to recognize, but a non-attorney wouldn't. Right. And it
makes me so upset with those companies that offer it, because it really hurts people.
Right, and they make it sound like it's so simple, but like for example, surgery, you wouldn't say, well, let me just do the surgery myself.
Right.
And it's very similar to the same kind of idea. It's an infrastructure of knowledge that you need someone that's very familiar and knows these rules. Right. And also can identify, well, if I'm planning this with my clients, sometimes they'll say, I want to do this or I want to do that. In the back of my mind, I'm thinking, okay, will this work or won't it work, or this triggers, that might not work to do it that way because of these other laws and these other ideas. And there's just no way in an online form or some form that you get from a stationery store to really navigate all those kinds of things. And those, a lot of times, those kinds of trusts end up in court after the person has passed away, because there's dispute. Even when you can kind of see what the person intended, there's sometimes it's vague, and so how can a court really decide on that? So
I had something recently, and I can't remember exactly what it was, but we had to jump through a lot of extra hoops because of an online situation and get extra notaries. I was going to the retirement home, and it was very time consuming.
And I've had situations like that before where clients, not that I've drafted these estate plans, but maybe they've tried to do it on their own and they passed away, and now we're trying to get the document valid, whether it's a will or a trust, and there are all kinds of mistakes, and so we have to try to argue. And if no one's disagreeing with the interpretation, that's easier, but a lot of times people might because interests are affected by it, right? And so taking a position might be advantageous to one person or another, and so it becomes a problem when things are not clear.
Any obvious hiccups that occur often with those things, or is it different for each one?
It's different. It's just knowing the circumstances and understanding what the client's intent is versus what the law dictates, and just understanding sometimes the legal terms. I guess one example, there was a court case in Florida a few years ago where the person was using the online form and they were listing every asset they have, itemizing it, saying where it goes, and then saying the rest, they just left that blank. And that, the rest was a very significant asset. Yes, was a majority. And so the court held that, well, if they didn't say anything, it would go to the person's intestate heirs. Those are the persons who would inherit if there was no estate plan. Because what the court very logically said was, you listed these specific individuals who are not the default beneficiaries because we wanted these people to get it. And the testator clearly thought that those were all of the assets they had, didn't understand the critical clause of, we call it the residuary clause, all the rest of the stuff, left it blank, and by default it went to the natural heirs, which other evidence indicated the person didn't want it to go there.
Right.
But when they're filling out the form, they just don't understand. They're just asked, list asset 1, 2, 3, 4, and 5, and they don't know what a residuary is, right?
And shame on the company for making the darn forms, but
and the
people
court
should
even
educate themselves on it. That's why you're here, to give free advice.
That's true.
To go get more information if you don't have it.
It's really important. And the holding of that case was that basically saying people shouldn't, try to do it yourself. They really need to have the guidance of a knowledgeable person.
It's like building a foundation on a house. You use the surgery analogy, I use the house. If you don't have the right contractors, your house falls down.
That's right.
So, well, thank you so much for explaining this and coming on Jette TV.
Always a pleasure.
Thank you. So how about giving your phone number?
Sure. My phone number is 831-920-0205, and my website address is www.krasalaw.com. That's KRASALAW.com.
Perfect. And we're here, Jette Ferguson Group at Sotheby's, 831-402-3800. Thanks for coming and watching the show.